Okay, I'm getting the green light to go. All right. Welcome everyone. Nurunj, Woman Inji, Nero Mukta Paul Payton, Naju Gunai, Naju Nagarago Minero, Naju Dunganai Waru Work. I'm pleased to welcome you all today to the sixth and final of this series of lunchtime webinars that we've been mainly developed from the insights and questions that were posed during the traditional owner engagement meetings back in 2019 around treaty, and also what we've learned since then. There's been a lot of advancement since then, so we've learned a lot, and that contributes to today's discussion. But I think firstly, importantly, in the context of this discussion, I want to recognise the work of the First Peoples Assembly and their development of a treaty framework and reinforce that these papers don't purport to represent a firm or fixed position of the Federation. Rather, they seek to contribute to the thinking around treaty making in Victoria. So as a statewide body that convenes and advocates for the rights and interests of traditional owners, this series of webinars aligns most strongly, but not uniquely, to one of our four strategic pillars, which is knowledge sharing. And that pillar is focused on enabling a more connected, informed and innovative traditional owner groups through the promotion of resources and events, information sharing opportunities. And whilst this is the final in this series, we certainly hope to be bringing more webinars to you in the future. So today's presentation is titled A Comprehensive Treaty Model for Victoria, and it's now available on our website for you to download if you haven't already done that. And it argues that a statewide treaty, it is a statewide treaty that will provide the foundation for a comprehensive treaty model. And as such, the paper will revisit the first papers 1 to 5 to examine those and reintroduce those what we suggest are the three fundamental elements of a treaty model, which is the Aboriginal Parliament, public service, the entrenchment of Aboriginal rights, and a framework for local treaties as well. So really important components that we want to discuss today. So without further ado, I'll welcome back Dan Kelly, who's returned to deliver the presentation to you today and answer any questions you might have on it. And I hope that you find it to be a valuable contribution to the current processes that are underway in the state of Victoria. So thank you, Kinitba, and over to you, Dan.
Thank you, Paul. Thanks for that introduction. I'll just share my screen and get up the presentation. I hope that's now displayed. As Paul said, so this is the sixth paper in a series of 6 papers. This is the final paper we'll be presenting on this topic. As Paul said, that we don't suggest that these papers represent the views of traditional owners, but they are put forward really as a attempt to start to put some concrete propositions around the rhetoric that sort of surrounds treaties, so to sort of look at the practical ways that terms like self-determination could be implemented in Victoria. Just so people know, I can't see sort of comments or questions while giving the presentation, but if you'd like to put any questions in the Q&A, the Q&A box down the bottom, we'll have a portion at the end of this presentation where we can answer any questions you might have. So as Paul said, there's 6 papers in total. This is the 6th. This one hopes to sort of bring together the thinkings and learnings of the previous papers and describe a comprehensive picture of what treaty might look like in Victoria. Just to give you a bit of an overview of the model that we are talking about or proposing, we foresee that there will be a statewide representative body, which we refer to in the papers as the Treaty Representative Body, or the TRB. That would be something like what is currently the Assembly, or perhaps a further iteration of the Assembly, representing traditional owners and Aboriginal people from right across the state. That body would then enter into a statewide treaty with the state of Victoria. And within that treaty, there'd be a number of components. But we looked at, if you go to our paper 1, you'll sort of, that discusses that idea of establishing that statewide treaty as sort of a base step. But within that treaty, there'd be a number of measures. The first would be recognising the TRB as a sovereign body. So that means it would have to have some sort of sovereign powers. That might be legislative power, a voice to the Victorian Parliament, or reserved seats in the Victorian Parliament. And we'll be going through that in a bit more detail as this presentation goes on. But if you want to see the sort of real nuts and bolts of our argument around that, you can look at paper 2. Recognition of Aboriginal rights would be another major component of a statewide treaty. This we see really as the entrenchment of UN DRIP, both within the treaty process itself and as within the Victorian domestic law. We look at that in paper 3, and we'll also be going over that today as well. Aboriginal control of Aboriginal affairs has been a long-term aspiration for Aboriginal people and traditional owners. This is really extending thought around the TRB and its operation as a sovereign body, and what it would look like established as an Aboriginal parliament, and having been transferred the power and resources of the various government departments and branches currently operating in Aboriginal affairs. The detail on that is in paper 4. And then finally, while all of this is really concerned at the statewide level, we think a vital component of any treaty process is going to be local treaties or traditional owner treaties. And so that is treaties with the First Nations or clans spread throughout Victoria at that local level, and allowing for sovereign rights to be exercised on country. And you can look at that in greater detail in our paper 5. So today, as we've said, the title of this paper is A Comprehensive Treaty Model for Victoria. And it's really trying to build on the 5 papers that we've previously presented on. And you can find all of those papers on the Federation website, as well as links to these style of seminars that I've given are also available online. So it was in 2008 that Victoria became the first Australian state to enact legislation to facilitate the making of treaties with its Aboriginal citizens. That's 4 years ago now, or approaching 4 years ago. And since that time, you know, there's been a lot of advancements. We've seen the development of the Treaty Assembly. They've started to enunciate their positions around treaty, much of which has been sort of anticipated or discussed in this series of papers, things like a statewide treaty and local treaties, and the establishment of an ongoing democratic Aboriginal and traditional owner body. So as I said, in this paper, we're trying to put all of that together and give a picture of what a comprehensive treaty model might look like. And we say that it really has 3 essential components. The first would be an Aboriginal Parliament and public service. The second would be recognition of Aboriginal rights. And the third would be the framework for local treaties. So these are the sort of 3 components of this presentation, which I'll go through in turn. So the first, looking at this concept of an Aboriginal Parliament and public service, at the core of this idea of an Aboriginal Parliament is, we say, the recognition of the TRB as a sovereign body. As we argued in paper 1, traditional owner groups are the relevant sovereign bodies in Victoria. These are the nation's clans, native title holders, however they might be described, that are the continuation of the First Nations that existed here before invasion and still assert sovereignty today. Now, so while we have a quite wide collection of sovereign traditional owner bodies across Victoria, it's not uncommon for smaller sovereign entities to voluntarily form larger sovereign entities and therefore bind together to meet common problems and to take advantage of opportunities that they can get from that larger scale. In a political context, you know, we see this in the Federation of Australia. in the United States. These are examples of federations where smaller sovereigns politically band together to create a larger body. There is, we say, also sort of cultural precedent for this in the Victorian context, and we'd all be familiar with the core nation, made up of 5 individual nations, operating today in Victoria as independent sovereigns, but also forming the larger Kulin nation. So this is a role that we think the TRB could play, coming together as a confederation of traditional owner groups. It could be conferred sovereignty to act limited to certain statewide matters. That, of course, leaves the question of what would these sovereign powers look like in practice? What would the TRB be doing? We say there's really sort of three components to this, or 3 options. The first is to operate as a traditional owner parliament. The second, to act as a voice to the Victorian Parliament. And the third, to select members to take up reserved seats in the Victorian Parliament. But in fact, we don't see these 3 as necessarily exclusive, and there could be some combination of the above that could operate to sort of recognise the sovereign status of the TRB. In this paper, we're really going to focus on those first 2, the idea of the TRB operating as a parliament, and also incorporating some concept of a voice to parliament. And in fact, in the context of treaty, we see that voice in a sense of being reciprocal, of this continuing relationship between the Victorian Parliament and the Aboriginal Parliament, and each having their sort of defined areas of jurisdiction where they're independent, but having this reciprocal voice between the 2 to allow for that ongoing relationship that is going to have to continue. Thinking now of what that independent area would be for the TRB, or what would be its jurisdiction in respect to lawmaking, we suggest that the 6 domains that are set out in the Victorian Aboriginal Affairs Framework, or the VAF, are a useful starting point. So the VAF is it's a Victorian government document, but it's a document where firstly kind of examines all of the interactions between the Victorian government and the Aboriginal and traditional owner community, sort of takes account of all those policy areas and programs that are currently being rolled out, and tries to kind of arrange them in a comprehensive and cohesive kind of framework. And in doing so, it identifies these 6 areas in which it's operating with the Aboriginal community. They're pretty self-explanatory: children, family and home, learning and skills, opportunity and prosperity, health and well-being, justice and safety, culture and country. So we think of these as essentially a good marker for the sorts of things that TRB may want legislative power over. And we would see them taking the transfer of power for these areas could happen in a sort of staged process. We would see it commencing with the transfer of ministerial and departmental responsibility and resources. And you could think of each of these areas essentially, if the TRB is a parliament, then these are sort of separate portfolio areas. And around each of them, the TRB could begin to develop internal departments, each being headed by a member of the TRB executive. And that would essentially be an equivalent role to that of the minister in the Victorian government. So it's what we refer to as a TRB minister. So once the transfer of power commences, for a period of 12 or 24 months, it could be that the Victorian minister and the TRB minister would engage in a process of co-governance. And so that would mean that in all those areas under these portfolios where there was a decision in relation to Aboriginal affairs, the ministers would have to jointly approve all decisions in those areas for that period. But the central purpose of this time period, be it 12 or 24 months, would be to facilitate the transfer of resources from the Victorian government to the TRB and really establish that Aboriginal public service and building up the TRB so it could take sole responsibility. Once the resources are transferred, it would be the TRB minister who then held sole responsibility. They would have beneath them now a fully functioning department. They would also have the experience of acting as a TRB minister in a co-governance process for a period of time, and they'd be capable of taking over all policy, design and administrative functions. At that time, they would also take on take up the TRB's legislative powers, and would then have the power to sort of create new legislation in each of the domain areas and begin a process of reform. As we've discussed in our previous papers, and as can be seen from all the international examples where there is Indigenous self-governance, there is in each example there is some requirement that that there is some oversight or involvement of the settler political institution with respect to the Indigenous self-governance body. This is, we think, probably an unavoidable component of any Victorian model. And to some extent, there does need to be a relationship between Indigenous governance and settler governance, because they will be continuing to both occupy the same land. But we say that this sort of needs to achieve a balance that respects the independence and sovereignty of the Aboriginal Parliament, but it's also going to need to take account of the constitutional limitations in the Commonwealth Constitution about how far the Victorian Parliament can actually go in handing over power. So one way we think that this balance can be achieved is by sort of establishing a scale of decision making. So this would be a scale that takes account of the concerns of both the Aboriginal Parliament and the Victorian Parliament, and contains a range of processes sort of to negotiate an outcome depending on where the particular decision sits on that scale. So thinking of that scale at a very basic level, on the one side you would have decisions that only impact the Aboriginal or traditional owner community, and on the other side you would have decisions that impact on Victorian citizens, which also includes Aboriginal people, of course. So the Victorian Parliament would have some interest there. We would say that where a decision is only going to impact Aboriginal or traditional owner interests, the state does not really have a direct interest, and the TRB should be able to act with essentially unfettered independence. But where there is, where an action or legislation of the TRB may impact on non-Aboriginal Victorians, the state may be entitled to some sort of greater involvement or say. So to break that down a bit further, we see the scale really as been made up of three categories. So category one would be decisions internal to the Aboriginal community. Category two would be decisions relating to how the state interacts with Aboriginal people. And category three would be decisions that will impact on non-Indigenous people or interests. Under that category one, we say that the TRB has complete authority to pass legislation. Sorry, I'm just apologies for that. So yeah, we would say that the Victorian Parliament may be able to give its view in respect to those matters, but complete authority would rest with the TRB. Decisions under that category would be things such as formally recognising traditional owner groups or settling boundary and other disputes between groups, perhaps also establishing dispute processes between groups. Category two, we again say that the authority of whether or not the legislation passes should sit with the TRB, but this would involve an obligation to consult the Victorian Parliament. So that is, the Victorian Parliament would have a voice with respect to these decisions, but the TRB would retain the authority. Some examples of what might be included in this category would be things like changing the way bail laws apply to Aboriginal youth, or changing the way child protection laws apply to Aboriginal families. In that third category, where there is going to be a direct impact on non-Indigenous interests, we think that the Victorian government is likely to insist that, as part of its own democratic process and makeup, it needs to have a say And we see that being achieved really by the legislation being passed by both the TRB and the Victorian Parliament. So we're going through both parliaments. Examples like that might be requirements around mandatory cultural heritage clearances on all developments, or traditional owner rights to veto developments on Crown land. And just to give a bit more of a general overview of how that process might work. So if you have the Aboriginal Parliament, it has jurisdiction over 6 domains. It has the ability to make legislation within those domains, to appoint administrative decision makers, and it has sole responsibility for policy design and administrative functions. In its relationship with the Victorian government, so this is what we see as being this reciprocal voice between parliaments, and this would sort of be the basis of the continuing relationship between the 2 parliaments. So essentially, if the Victorian government was going to do anything outside of the 6 domains, but it was likely or may have an impact on Aboriginal Victorians, then the Aboriginal Parliament would have a voice to the Victorian Parliament on those issues. And likewise, the Victorian Parliament would have a voice to the Aboriginal Parliament if the TRB or Aboriginal Parliament was going to do something that may impact on Victorians. So that kind of brings us to the end of our conception of the Aboriginal Parliament and public service. Just moving on to the next sort of limb, or we say, of the 3 limbs that are essential components to a comprehensive treaty model, and that is the recognition of Aboriginal rights. As we know, that the past few decades have seen Indigenous people increasingly have their rights recognised in international human rights law. The most prominent instrument recognising such rights is the United Nations Declaration on the Rights of Indigenous People, or UNDRIP, and that document is now endorsed by all UN member nations. So despite this sort of universal endorsement, unfortunately, the terms of the UNDRIP have not really been implemented into domestic law of nation states, of member states of the UN. There is a recent exception in Canada, which I'll go through in a moment. But because of its makeup, it's categorised as a declaration, the UNDRIP. Those form of international instruments are not legally binding on nation states unless they voluntarily adopt them within their domestic legal system. And of course, that means that signatories like Australia, that they're free to ignore the terms of the declaration at home. And, for instance, we see FPIC, or free, prior and informed consent, routinely ignored in Australia. But in international forums, they're able to sort of espouse their support for this, even while not actually complying with it at home. So this leads to the question of, well, how can the UNDRIP be enshrined in the treaty process in Victoria and brought into Victorian law? So looking at the international examples, we think there's probably 3 principal methods through which the UNDRIP could be brought into Victorian law or enshrined in the Victorian treaty process. The first is to embed the UNDRIP principles into treaty negotiation processes and protocols. So that's essentially ensuring that the UNDRIP is at the centre of all the sort of foundational documents around the treaty process. The second is to enact legislation that is directly bring the UNDRIP into Victorian law and affirming its application to Victorian law. This is what's recently happened in Canada. And as I said, I'll go through that in some detail in a moment. And the third would be to include UNDRIP rights as enforceable and justiciable rights within treaties themselves. That is, embed them as legally enforceable rights within treaty documents. So going through each of those in some more detail. Firstly, talking about embedding new UNDRIP principles in treaty negotiation processes. There is an example of this that comes out of British Columbia. In British Columbia, they have the BC Treaty Commission. The role of the BC Treaty Commission is to facilitate treaty negotiations. So it acts as something like an umpire between First Nations groups and the province of British Columbia and the federal government, the federal Canadian government. So this is a role that I think is probably somewhat comparable to what's envisaged for the Treaty Authority in the Victorian process. So in 2016, the functions of the BC Treaty Commission underwent a review, and at that time the Commission's mandate was extended to include supporting the implementation of the UN Declaration. So that is the BC Treaty Commission now views the BC Treaty process as one of its principal purposes being to achieve the implementation of the UN Declaration. So this means that now, if we think of the BC Treaty Commission as the umpire, then the UN DRIP is now the rules of the game. And so when the BC Treaty Commission is making assessments and looking at the behaviour and conduct of all parties to negotiations, it is now making that assessment against the terms of the UN DRIP. The BC process went further again in September 2019, and they adopted and endorsed the UN DRIP as the foundation of BC treaty negotiation frameworks. So that means now that all parties have to view the treaty and its purpose being for the implementation of the UN DRIP. So adopting this into Victoria, this would look like embedding the UN DRIP within the treaty negotiation framework, and the Treaty Authority should have this embedded within them. And the purpose of these structures and the entity of the Treaty Authority should be to implement UN DRIP in Victoria, and it should be reflected in all their processes and protocols. The second method by which we can bring in UN DRIP is the sort of direct legislation method. This again, we return to British Columbia where this occurred in November 2019, when they adopted the Declaration of the Rights of Indigenous People Act. So this bit of legislation, it really has four components. It's quite simple in many ways. The first thing it does is it affirms the application of the Declaration to the laws of British Columbia. It requires a process that government must take all measures necessary to ensure the laws of British Columbia are consistent with the Declaration. And it requires the government to prepare and implement an action plan to achieve the objectives of the Declaration. And lastly, they have to annually report to Parliament on the progress of the above. So this would seem a ready-made model for adoption within Victoria. It's a simple but sort of effective approach, we would say. It's interesting or novel kind of approach is that it simply declares the Declaration as applying to the local domestic law, and then requires a process of essentially going through laws that are already on the books and ensuring that they are in compliance with the Declaration. Now, Victoria has legislation in place which is somewhat similar to this already, although there are differences, and that legislation would be the Human Rights Charter. As you know, the Human Rights Charter, it requires all public authorities, state and local government departments to act consistently with 20 fundamental human rights that are set out in the Charter. And anytime a government decision maker or the Parliament is making a new law, they have to consider those 20 fundamental human rights and ensure that they're not doing anything in breach of them. The 20 rights included in the Human Rights Charter are taken from the ICCPR, the International Covenant on Civil and Political Rights, and it includes rights to things like freedom of expression, privacy, liberty, equality before the law, etc. So Section 19, or the Right 19 in the Charter, refers to cultural rights and does provide some protection for Aboriginal cultural rights as well. But that is the only mention of Aboriginal people within that document. Now, one distinction between the Human Rights Charter and what we see in the Canadian model is that the Human Rights Charter is forward-looking. So it will look at new laws, new decisions, new actions by government, and try to ensure that those things are compliant with the rights set out in the Charter. But it doesn't examine laws that are already on the books. So in Canada, they're developing up this action plan that will examine existing laws, and if there's inconsistencies found, there's an expectation that they'll be rectified and changed. So we think this remains open for the Assembly to advocate for the introduction of similar legislation, and based on the Canadian model, that legislation could both be backwards and forwards looking in terms of implementing the UN DRIP. So that is, like the Canadian model, it could adopt an action plan to seek out inconsistencies in existing legislation. And like the Human Rights Charter, it could ensure the application of the UN DRIP to all future decisions or actions of public authorities and to new laws being passed by the Parliament. And that, each of those would have to be assessed against the terms of the UN DRIP in something like a statement of compatibility that you see under the Human Rights Charter. Now, the final proposal of the three ways that we say the UN DRIP can be incorporated is not drawn directly from any international examples. And this is the idea of including UN DRIP rights as justiciable rights within treaties themselves and placing a positive obligation upon the state to ensure the realisation of such rights. Now, the reason we say you can't find international examples of this approach is because UN DRIP comes about in 2007 and there isn't any modern treaty process that has been designed following or after the introduction or endorsement of the UN DRIP. So that is why we say it's kind of a new approach. So what do we mean when we talk about justiciable rights? Well, justiciable rights are really just those rights you can have enforced by the court. Now, states are reluctant to agree to justiciable rights when they're open-ended rights, such as the right to self-determination. Simply placing a right within a treaty to self-determination has no clear defined limit on the obligations of the state. And the state is likely to be very reluctant to sign up to something like that. When it's not clear exactly what it would need to do to meet that obligation. However, we think that there is middle ground here. And the way we would see that middle ground working is that the treaty terms would establish minimum standards. So you would have a right to self-determination in the treaty, and then the treaty terms would set out certain minimum standards about what that right would look like, or the state would have to do for minimum compliance. And that would be, if you were to take the example of self-determination, that might be something like the Aboriginal Parliament. One of the benefits of including treaty rights UN DRIP rights as justiciable rights within a treaty would be that it should give you another avenue to take action, to take redress against the state if they were to breach that particular obligation. So, for instance, if they breach the treaty, there presumably would be an actionable term, or almost like a breach of contract type of legal action. But if there's an acknowledgement of an underlying human right, that provides yet another standard by which the state's conduct can be judged and challenged, and presumably the state should be held to higher standards where the action there or obligation they're doing is in service of a fundamental human right. So that brings us to an end to how we say Aboriginal rights should be incorporated into a Victorian treaty model. And we're now on to the third and sort of final component, which we say is necessary for a comprehensive treaty in Victoria, and that is a framework for local treaties. So we think it's clear that a statewide treaty alone is never going to satisfy the long-standing calls of individual First Nations for treaties. As we said at the beginning, individual First Nations or clans or traditional owner groups are sovereign, and they will want that sovereignty recognised and respected. So for that reason, we think local treaties or individual traditional owner group treaties are going to be fundamental to any Victorian treaty model. Now, traditional owners in the state have previously negotiated a framework for making comprehensive land settlements in Victoria. That's known as the Traditional Owner Settlement Act or the Settlement Act. It was designed by a steering committee in 2008, and it was designed as an alternative to the Native Title Act. And we say that the Settlement Act and the associated framework around it does provide some useful guidance to the practical implementation of much of the reform that would sort of also accompany the establishment of local treaties. So just thinking about what can be learned from the Settlement Act, it is worth perhaps reflecting a little bit on how it came about. So the Settlement Act is developed in the wake of the Yorta decision, where the High Court found that a loss of continuous connection to country could extinguish native title rights. That was quite a blow to native title holders in the southeastern states of Australia, where colonial policy had been to do exactly that, which was to break people's connection with country. And so it seemed to put native title beyond the reach of many groups. So the Settlement Act has had some success in overcoming the kind of legalistic and combative approach that you often see through native title claims. And instead, the state sort of in adopting this legislation said, look, rather than fight you tooth and nail in the courts, we're going to sit down and we're going to make agreements, and we're going to make comprehensive agreements about country. The Settlement Act process also promised to produce speedier and more efficient outcomes. Native title claims are notoriously slow. I think Yorta went for 11 or 12 years, and that would certainly not be at the higher end or longer end of how long native title claims can run. So it was hoped that this agreement making would resolve claims quicker. Unfortunately, not all of the aims of the Settlement Act have been achieved, we would say. And we say there's really two issues arising from the Settlement Act, which will need to be addressed and resolved in a local treaty framework. The first is that, unfortunately, the Settlement Act doesn't seem to have resulted in a more efficient system of claim resolution. It's now 10 years of the Settlement Act, longer now, probably 11, 12 years of the Settlement Act, and we've only had 3 agreements reached in that time. So a local treaty framework will have to find a more efficient process. Also, we say the Settlement Act relies on a really rigid framework, and it tends to deliver up to traditional owners these cookie cutter deals. That is, there's a pre-packaged sort of settlement, and that's what's put on the table for TOs. And that framework is not always able to respond to individual group aspirations, and it's not always able to keep pace with changes in native title law. So there also needs to be more flexibility for treaty outcomes. Just thinking for a moment about why the Settlement Act has not been as efficient as was hoped in resolving claims. We think this really arises because it fails to adequately address the prevalence of disputes created by post-colonial land reform. I mean, the prevalence of disputes around traditional ownership was acknowledged by the steering committee back in 2008 when they designed the Settlement Act. And they said at that time, there is limited support and incentives for resolving intra and inter-Indigenous disputes over group composition and boundaries. These disputes can be complex and seemingly intractable and stand in the way of the resolution of native title. So in response to this problem, what the steering committee did was they established the Right People for Country project, and this was meant to be a transparent, respectful and non-adversarial process to identifying the right people for country. This approach had a lot going for it and was useful in a lot of ways. Firstly, it aimed to avoid or minimise intra and inter-community trauma that is really quite prevalent in native title processes. And second, it sought to be Indigenous-led and consistent with powers of self-determination and community decision-making. The problem is, we say, is that currently under the Settlement Act processes, mediation is the sole method to address disputes. And if, as the steering committee identified way back in 2008, if these disputes really are intractable, by definition, they can't be resolved by mediation. And by allowing that as the only option, there is the risk that these disputes will only be prolonged and will only continue to cause trauma within the community. So for that reason, what we say is needed is a release valve. This would be a process whereby parties get a fair hearing, followed by a workable resolution. And hopefully, going through that quick and open process will allow for the re-establishment of functional relationships and healing within the community. As things currently stand, because there is no process other than mediation, what happens is parties are thrown back into the Native Title Act processes. And these are the very processes that the Settlement Act was trying to avoid because they're adversarial, they're legalistic and technical and culturally unsafe. So in thinking about wider options for dispute resolution, as I said, if mediation fails, you really are stuck back in the federal court with the Native Title Act. But treaty, we say, presents this unique opportunity for traditional owners to essentially self-determine their own arbitration process and make it fit for purpose for Victorian traditional owners. So this could be a process like an NTA court process in some respects. It could be a forum to hear evidence and hear all of the evidence and all of the witnesses and issue decisions. Unlike an NTA process, it would not be concerned with the legal technicalities of the NTA, and instead it would be focused on the factual questions of actual importance to traditional owners. This would be things like the location of boundaries and questions as to the extent of country, issues of group composition, including the appropriate inclusion of ancestors, and the potential inclusion or alleged exclusion of particular family groups from participating in the wider traditional owner group. So naturally, this process would be designed by traditional owners or perhaps the Assembly, but it could take the form of a tribunal within the treaty authority. This could be a relatively informal in nature, but it should also apply a disclosed and clear legal methodology to arrive at finding of fact. It could consist of a panel of elders who would be empowered to make the decision. They could also be assisted by a former High Court or federal judge. One thing to be clear of about this process is that it could not displace Native Title Act processes. So the Native Title Act is Commonwealth legislation, and it could not be displaced by any state process. But it could be made to align with those processes, so that this could be essentially a fact-finding process that happens before any decision or any matter winds up in the federal court and comes to a sort of self-determined decision about who are the correct traditional owners. We also say that this process would necessarily require all parties to the dispute to be equally resourced and have access to the relevant historical, anthropological and legal advice. We would also hope that the self-determined nature of the design would give this forum a sort of cultural credibility and would discourage Aboriginal people from relying on settler institutions like the court when they could instead rely on this process. We also think it should be public, as much as possible, subject to cultural considerations, and create a public record about traditional ownership. I'm just conscious of time, so I'm just going to whip through these last few slides. Thinking about the inflexibility of the framework and this idea that traditional owners sort of get these cookie cutter results under the Settlement Act. In 2008, when this was designed, the state and traditional owners were responding to the outcomes that were available, the standard outcomes you might get under the Native Title Act at that time, and then applying them universally across the state. The state, of course, has an implicit interest in having uniformity in traditional owner deals, because a lot of these deals resolve around rights to land and natural resources, and they want to operate a cohesive land management system across the state. They also want to treat all traditional owner groups equally, so they don't want to give rights to some traditional owners and not others. They want to be respectful to all traditional owner groups. The result of all this is that you get this highly structured and sort of inflexible framework, and that if any traditional owner group tries to sort of do something outside of that framework, the state can't just do that. It has to realign the whole framework to accommodate it. And so any sort of minor adjustment becomes a sort of statewide issue. So this means that when traditional owners enter those negotiations, it means that some things are going to be negotiable within the framework, and things outside the framework are going to be more difficult. Yeah, so by the time that a TO group arrives at the negotiation table, they can find many of the positions settled. They're either locked in by the original steering report from 2008, the legislation itself, template agreements that often form the basis of these deals, or the positions that were agreed by the traditional owners that came before them in the negotiation process. So, thinking about local treaties, what will be in them? We think there will really be two components to a local treaty. The first will be a compensation and rights component. The second will be a political component. The compensation component, we say, will probably be similar to, but should be in excess of what you get under a Settlement Act agreement. The political component should be what recognises the group as a political community and allows it to engage in some form of self-government. Under our model, we think these two components could be dealt with in two distinct phases. The first, we say, the compensation and rights component could be included in a minimum rights package. This would be collectively negotiated by all traditional owners, and it would be immediately available to traditional owner groups on them passing some agreed thresholds. And then they would implement that package for a couple of years. There would be a very quick rollout, and groups would be implementing these together, meaning there would be opportunity for sort of joint learnings, and where problems with the package were negotiated, it would be quite easy for the state to realign and renegotiate certain aspects on that larger scale. After that minimum rights package has been implemented for some period of time, it's going to give the traditional owner group a lot greater capacity and experience. And we say at that stage, the state should really be required to abandon standardised solutions and engage with traditional owners on a sovereign to sovereign basis and on an individual basis. So the minimum rights package has a number of advantages. We think TOs can probably get better outcomes by negotiating collectively. By negotiating collectively, they sort of lessen the power imbalance with the state. And by making it immediately available, it would encourage the efficient resolution of claims. And as I said, the quick rollout would mean that would apply across Victoria very quickly. And this would encourage both systemic and cultural change within government departments. Finally, it could overcome some of the rigidity and inflexibility identified in the settlement framework through a collective TO body sort of negotiating changes to the framework as needed. And that brings us to the end of our view of a local treaty framework. And accordingly, that brings us to the end of the paper and the presentation. So that is our view as to what a comprehensive model for Victoria might look like. I'd encourage anyone, if you have a particular interest in any of those components, you can certainly find more detailed information in each of the individual papers. So with that, I might throw back to you, Paul. I'm just noting where we are for time. I might throw back to you, see if there's any questions.
Great, thanks, Dan. A really comprehensive and thought-provoking paper there. I really got a lot out of it, and I hope everyone did. And there's a few questions. I had maybe a question, if I can lead off, around the Settlement Act and the local treaties, and where does that leave the Settlement Act going forward? Is it something that the Settlement Act takes a back seat, or is it something that builds on the Settlement Act going forward if local treaties are negotiated?
I think I think where deals have been done and there's Settlement Act agreements in place, and there's certainly where there's native title outcomes in place, I don't think the state can disturb those, and it needs to build on top of them. The Settlement Act itself, I think, should probably be incorporated into a whole new bit of treaty legislation. I don't think I think there's probably too much legislation at the moment. You have the sort of overlying Heritage Act and the Settlement Act and the Native Title Act. I don't think we want to add another piece of legislation on top of all of those that doesn't incorporate them. So yeah, I think it's certainly about building on those outcomes, but I think it's also time to sort of clean house a little bit in a legislative manner of speaking and develop a cleaner new model.
Yeah, certainly can start to get a bit messy with all these various layers. We'll go to, there's a couple of questions I can see in the chat. I'm not sure if you can see them as well. On there from Jason, great presentation. The principles behind this model are unarguable. The question on scale, is the size of the potential bureaucracy on top of the current Aboriginal bureaucracy, thinking about Uralkin Assembly and the 30-odd ACHOs and more, is that appropriate for our community of 50,000 Aboriginal people in the state?
Well, everyone would be guaranteed a job in the bureaucracy, wouldn't they? Look, I think I take your point, and I would see it ultimately as being sort of rationalised, I suppose. So all of that bureaucracy would ultimately sit sort of within the Assembly, or reporting to the Assembly. So yeah, I take your point. There would have to be some rationalisation. ACOs are a little bit different because they're independent of government. They're not necessarily just going to be transferring their resources into an Assembly bureaucracy, and arguably they shouldn't anyway. So yeah, look, is there scope for too much bureaucracy? Yeah, always. But yeah, there would have to be some sort of process, I think, of rationalisation. And I think in that initial transfer of power stage, there probably would be a lot of duplication. But I think as you got down the line, it could probably be streamlined into a functional sort of process.
Yeah, certainly.
Hope that answered.
Sort of untangling and streamlining, as you put it, as to be able to get the best optimal outcome, balance of everything. There's another one from Tara. It says, I can see some of the way treaty is politically insulated in the model. I'm wondering if you had any views on legally protecting it with constitutional change and how that might be achieved.
I presume you mean constitutional change at a Victorian level. Yeah, I think constitutional change within Victoria probably is important. But I don't know how effective even that is, because the Constitution of Victoria is easier to change than the Commonwealth Constitution, which probably means that embedment within the Victorian Constitution is less secure than you would see in a sort of voiced or Uluru Statement model. But yeah, I do think legal protection of the treaty is always a tricky one. If the government were to abandon treaty or turn hostile towards treaty, it would be difficult to keep it stood up, I think. So I think a lot of the thought does have to go into the sort of political protections that can be put in place.
Yeah, absolutely. Certainly, yeah, needs to be considered as part of that process. A couple more coming in from Dane. Great to have the opportunity to hear about the presentation, the possibility of bringing UNDRIP into law. As you've used Canada as an example, has there been any attention paid to certain Indigenous communities' rejection of the UNDRIP that has passed Canada's Parliament? You've heard of that, but have you heard of CANDRIP?
Sorry, I'm trying to find that question so I can see that written up. Wonderful to hear a possibility of bringing you under. No, I'm sorry, I'm not across the objections to CANDRIP, which I imagine is the Canadian federal legislation, which I think is modelled after the BC legislation. So no, I'm sorry, I can't respond to the Indigenous community's concerns about that in Canada. Yeah.
yeah, it's something probably, I hadn't heard of it either, so it's something I guess we'll all learn more about as sort of information comes out about that.
Mm.
Any other questions?
I see Tracy's comment there. Not sure if I agree with stopping a TO to taking their own rights in their hands on country. That seems quite colonial. Yeah, I get that, and I assume what you mean from that is like the assembly kind of having some power over country. Not that they would, but that traditional, the assembly taking some higher role that might be above the local traditional owner role. Look, I get that might be uncomfortable for some people, and I think they're all issues to be debated. I think having looked at it though, sort of what's on the table in treaty is so much more if you can get some sort of state level coordination. If you just stick to that local level, we suggest that the content of the treaties is going to be so much less. So these are trade-offs, and I think what Tracy raises there is really a cultural question, which probably I'm not the person to answer.
Certainly, yeah, there's some issues that need to be worked through around cultural authority and ensuring that rights are protected through that process. Lawrence says, would we be seeing an Indigenous Affairs Minister soon? I think that's certainly on the cards.
Hopefully.
Yeah, hopefully, certainly sooner rather than later. Don't see any other questions, so I think we're right on time. So again, whoop, Tracy, definitely thank you. Thanks again, Dan. Like I said, a really comprehensive, deep thinking, thought-provoking paper that I think can definitely contribute to how we go forward in the treaty space and ensuring that traditional owner rights and control over Aboriginal affairs is certainly enshrined in legislation, and how we go forward to be able to ensure that everyone's future it benefits all. So thank you everyone for attending today. I hope you got a lot out of that, and yeah, please share it. We'll put the video